I'm Alexa Schwerha with Campus Reform, and you're watching 5 Big Questions. The Supreme Court is set to hear challenges against Harvard University and the University of North Carolina to challenge affirmative action and how it is applied to the admission process. And this isn't only on college campuses. We're seeing it play out in society. President Joe Biden looking to fulfill a campaign promise to put the first Black woman on the Supreme Court. Here to tell us more about that is Professor Mark Caleb Smith. Dr. Smith is a professor at Cedarville University, where he also serves as the director of the Center for Political Science. His research focuses primarily on religion and American politics. And Dr. Smith, we're so excited to have you here today. Thank you so much for coming on.
It's my pleasure to be with you.
Of course. So to start us off, I want to go back to an interview you recently did on WHIO radio, where you were talking about how putting a person on the Supreme Court based on race and using race as qualifications isn't necessarily a left-leaning strategy. It's been used by presidents on both sides throughout history. Can you expand a little more on that?
Sure. So think back to when Ronald Reagan was president. There'd never been a woman on the Supreme Court before. When he was running for election and early in his term of office, he made it clear that he wanted to choose a woman while he was president. An opening became available, and he ended up choosing Sandra Day O'Connor as his nominee. A similar situation with George Herbert Walker Bush. So the first President Bush wanted to have an African American on the court, and a position became open, and he chose Clarence Thomas to fill that seat. And so, I understand why sometimes people on the right would be critical of identity politics, and I think there's plenty of room to be critical of it. But sometimes people on the right engage in similar sorts of reasoning, at least when it comes to the Supreme Court.
Right. And when we're talking about these challenges, against Harvard and the University of North Carolina, what can our viewers expect to see happen during the oral arguments? And do you think that Justice Breyer's retirement is going to affect the outcome?
It's a really good question. The last time we had a significant affirmative action ruling by the courts, 2016, in a case Fisher versus University of Texas. Of the 4 people in the majority there, only one of them will be at that oral argument when that happens in October. Justice Breyer is going to retire. Justice Ginsburg, of course, has died. Justice Sotomayor is still there. Justice Kagan recused herself in that case. Justice Kennedy has been replaced. And so the court has definitely changed dramatically since it heard a significant affirmative action challenge. And so the oral arguments, I think, will be interesting to get a window into how the court's processing this issue as of right now. We can look at people like Justice Thomas for sure and Justice Alito, and I think you can assume they're going to be pretty staunchly opposed to government-backed affirmative action policies. They're going to see them as in conflict with the Constitution. Of course, the wild card is going to be the newer appointees, Justices Gorsuch, Kavanaugh, and Barrett, and how they might respond. We just simply don't know enough about them, I think, to have a definitive idea of how they'll approach it.
Right. And one thing that I find really interesting about these cases is it's challenging one school as a private school and another school who is public. Is this going to have any impact on how the court rules?
It will. I mean, in the Harvard case, the challenge is based on the Civil Rights Act of 1964, and particularly Title VI, which prohibits institutions that receive federal funding from engaging in racial discrimination. And so the argument is Harvard's discriminating against African or Asian Americans in particular, who are arguing they're being admitted at much lower rates than whites who are similarly qualified. And so they're going to make a federal argument based on the law. In a case, they're going to make an argument based on the law as well as the Constitution, because as you said, North Carolina is covered by the Equal Protection Clause in the 14th Amendment in a way that Harvard is not. And so it'll make for an interesting wrinkle. The courts combine these 2 cases in oral argument. There's a good chance they'll combine them when they write their actual opinion. Will that difference be enough for the court to treat the 2 cases differently? The Harvard approach is acceptable because it's a different standard of review, for example, than the North Carolina approach. I think it'll certainly play a role. I can say, though, I think the court's going to prefer to have a fairly standard approach to both cases to have a clear signal sent if it's possible.
I imagine. And one thing we see here at the Leadership Institute's Campus Reform is that what happens on a college campus happens to become the mainstream in society. And we're seeing affirmative action play out both in the public and the private sector. We talked a little bit about Joe Biden and how his Supreme Court nominee is going to be a Black woman to fulfill that campaign promise. But United Airlines also recently announced that to increase their diversity, they want half of its pilots to be women or minorities by the year 2030. Now, what do you think this precedent is going to set for how society considers race-based admissions and race-based qualifications?
When we look at public opinion polling, which is interesting on affirmative action, generally people are opposed to it in the way that it's presented to them. And so I don't think these are widely popular policies or widely popular approaches to hiring in particular. There's always a frustration that people are being chosen without merit in mind. They're being chosen based on other factors. At the same time, there is, I think, a fairly broad understanding that African Americans in particular have suffered a unique history of discrimination in our country. And so those two things, this opposition to affirmative action on the one hand, sympathy for the plight of African Americans historically on the other, those two things are generally, I think, popular in our country, but they contradict each other to some extent. And so I think that's one of the reasons why you see such ambivalence when it comes to the kind of program that you're describing. I think you're right, though, that trends that are on college campuses often filter into the rest of society. We've seen that very powerfully, I think, over the past decade. But I think the general trend has been really against affirmative action in higher education. There's been more restriction against policies, I think. Even in California, there have been efforts to roll back their prohibition against racially based admissions at their state schools. And those efforts have failed at the statewide level, even a place like California. And so how this plays out, I think, is going to be very interesting. You hope that maybe over the next decade or 2 decades, this recedes as an issue. But we've been sort of hoping that at least since the 1960s.
Right. And to just wrap us up here, can you explain how a ruling in favor of the students for fair admissions and how a ruling against would impact how affirmative action is used in this country?
I think it could have a significant impact. I mean, the argument that's always come across, I think, very forcefully from the right side of the spectrum is that institutions, whether they're public or private or whatever, are free to engage in certain kinds of discrimination. I use discrimination as that word lightly. Whenever I use it, people sort of their backs arch up and they get upset. But what we're really talking about is the ability to make choices, and that involves a discriminatory process. And so which factors can you do that on that are legal, that are acceptable, and which factors can you do that on that are not? Justice Scalia, for example, famously argued, and I think persuasively, honestly, that really maybe we should just be engaging in economic discrimination. Admit more people who are of lower socioeconomic status, people who are disadvantaged currently. There's no constitutional protection against that, for example. I think those approaches are going to find much broader support over the long term than racially based forms of discrimination, even if they are sort of dressed up as affirmative action. So if the court strikes a very heavy blow against these affirmative action policies, I think you will see a ripple effect.
Fantastic. Well, Professor, we appreciate your insight. Thank you so much for coming on today.
Thank you. It's my pleasure.